Welcome to EUPrivacyForAll. Session 2 on GDPR will be dedicated to consent, that is to say to Article 6.1a, but also 7 and 8. After tackling DPIAs, let's focus on consent. Notification will be presented later on in a different session. The first provision of GDPR referring to consent is Article 6.1a, about lawfulness of processing. It stresses the fact that the data subject's consent is the first legal ground to process data. Article 7 frames conditions for consent. Each controller shall be able to demonstrate that consent was given by the data subject to the processing of their personal data. The second paragraph focuses, in the frame of written declaration, asking for consent on different matters, on the fact that the request for consent must be presented in a manner which is clearly distinguishable from the other matters, intelligible and easily accessible. The third paragraph recognizes the right to withdraw consent. It should be as easy to withdraw consent as to give it. Finally, the utmost account should be taken whenever a consent makes a whole service conditional. Child's consent is framed separately in Article 8 with regards to information society services. The processing of personal data of a child below the age of 16 or, if provided for by member state law, a lower age which shall not be below 13 years, entails an authorization by the holder of parental responsibility over the child. Basically, the controller shall make reasonable efforts to verify the age of the person concerned. Other key points from the GDPR are Article 4.8, the definition of data subject's consent. As in the directive, it should be freely given, specific and informed. Additionally, it should be unambiguous. That is to say concretely that it should be provided either by a statement or by a clear affirmative action. There are 3 cases in which explicit consent is required. First case is processing of sensitive data. That is to say, personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union memberships, genetic data, biometric data, or any kind of health or sex life and sexual orientation data. Second case is automated individual decision making, including profiling. This is a brand new provision compared to the directive. Third and last case is data transfers in the absence of an adequacy decision or of appropriate safeguards. What about negotiations and discrepancies regarding consent? European Parliament was requiring explicit consent. It clearly appears in Recital 25. Consent should be given explicitly. On the contrary, EU Council added a wording, unambiguous consent, and replaced in the same recital explicitly by unambiguously. This was not retained in the final draft. However, the fact that it could be done electronically or orally was retained. What's in the directive and currently applying? Article 2H defines data subject's consent. The 3 key items of freely given, specific, and informed indication of the data subject's wishes appear in this article. Article 7a, dealing with the legal grounds based on which a personal data processing could be carried out, mention the fact that the data subject has unambiguously given his consent. Sensitive data that are framed by Article 8.2a requires explicit consent. Finally, data transfers to a country not ensuring an adequate level of protection require that the consent given would be given unambiguously. What should accountable data controllers get prepared for? 4 things. First, collecting consent unambiguously or explicitly, depending on cases. Second, documenting such a collection. Third, being ready to demonstrate it was done for each single purpose of the processing. And finally, in the case of Article 8 regarding child's consent, verifying the age. Recital 25 specifies what a clear affirmative action is. Freely given, specific, informed, and unambiguous. But also concretely, it could be provided in writing, but this is not mandatory. Ticking a box or doing so orally could be a solution. Silence, pre-ticked boxes, or inactivity, however, should not constitute consent. In cases in which multiple purposes are to be served, consent should be granted for all of the processing purposes. The wording might be tricky. It apparently entails that consent would be provided for each single purpose. We know that Working Party 29 already provided different opinions on consent. However, due to new provisions in the GDPR, it might be really useful to get additional guidance from the EDPB.